Well, it looks like we are approaching critical mass. We'll kick today's webinar off. Good morning and welcome, everyone. Thank you for joining us for today's Fundamentals in Healthcare Law webinar, which is focused on patient care. My name is Jason Castor. I'm the Chief Business Development Officer for Parsons, Behle, and Latimer, and I'd like to welcome all of you to today's presentation. Thanks again for taking time out of your busy schedules to be with us this morning. Before I turn the time over to our presenters, I'd love to cover a quick few logistical items. First, today's webinar is being recorded, and you will be provided a link via email to the recording within 24 hours to share with your colleagues and teams. This email will also include a copy of today's PowerPoint presentation, along with a link to our Fundamentals in Healthcare Law curriculum on our website, which will provide you with information on upcoming seminars. Second, we'd like today's webinar to be as interactive as possible. So please submit questions using the chat feature throughout this morning's discussion. We've also allotted time at the end for Q&A. And finally, it's important to note that today's presentation is considered a general source of information and is not intended and will not serve as a substitute for legal counsel on these issues. You should not act upon the information provided without consulting legal counsel. So now that we've got the housekeeping items taken care of, I'd like to turn the time over to my colleague, Kevin West. Kevin is a shareholder in the firm's Boise office and is the chairperson of our healthcare practice. He focuses his practice on healthcare law involving audits, investigations, medical malpractice, and licensure board disciplinary matters. Kevin, I'll turn the time to you.
Thank you very much, Jason. Welcome and good morning to everyone. My name is Kevin West. As Jason mentioned, I'm a shareholder in the Boise office of Parsons, Behle, and Latimer. We're a regional firm with offices in Idaho, Utah, Nevada, and Montana. Today is the first of a series of 12 webinars, one each month that we'll be doing on healthcare law. And we hope that those of you who are listening, who are healthcare providers, who are staff in healthcare facilities, and those in academia and others will enjoy these monthly classes. And for those who complete the entire course, we are going to provide a certificate of completion to you. You see here the 12 topics that, let's see, Jason, there we go. All right, just advancing the screen. You see the 12 topics that we'll be covering over the next 12 months. And I think these will provide a very thorough and broad perspective on healthcare law. So the three presenters today will be myself, Andrew Alder, shareholder in the Boise office, and Ed Cather, a shareholder in the Idaho Falls office of the firm. Our topic today is patient care, and in particular, exploring various aspects of the provider-patient relationship and how that impacts patient care. We're going to divide that into three sections. I'll be starting out talking about the formation of the provider-patient relationship, some aspects of patient consent to treatment. Then Andrew will take up termination of the provider-patient relationship to do with competency, powers of attorney, living wills, etc. So with that, let's talk and begin really at the beginning, which is the formation of the provider-patient relationship. And just so you understand, as far as my terminology, usually we say doctor-patient relationship, but there are many other providers other than medical doctors, so I'm going to use a more general term of the provider-patient relationship. So several very important things hinge on whether there is actually a provider-patient relationship. For example, there is no liability for malpractice unless that relationship exists. Furthermore, a patient cannot continue to be treated or seek ongoing treatment unless there is that relationship, and the doctor or provider typically will not be able to be reimbursed for their services unless that relationship exists. So that is an important fundamental. Interestingly enough, where do we go to legally to look and see whether a relationship has been formed? Well, we actually look to the law of contracts. And in the law of contracts, we have basic formalities such as, was there an offer made? Was there an acceptance of that offer? Was there a meeting of the minds on the terms, the key terms of the relationship? These are the basic aspects of contract law. And in contract law, there are express contracts and implied contracts. And in express contracts, we are looking at the words of the parties, either written words or oral words, which actually state or affirm that there is a contractual relationship between the parties. By contrast, in an implied contract situation, we're not looking so much at the words, but rather the actions of the parties. And we are looking to see whether the parties, by their actions, manifest that some type of relationship has been created. And I know that's a little bit technical, but as we discuss some different areas, these distinctions between express and implied contractual relationships will take on greater meaning. So one question that comes up, are providers obligated to accept every patient who walks in the door? In other words, do they have to essentially contract with everyone who walks in the door? And the answer is generally no. There is freedom of contract. We are free to make relationships with those we choose, unless, and the major exception to that, if you are a participating provider with, say, Blue Cross or Select Health or some other third-party payer, you need to look at your contract with them and make sure that they do not require you to accept all patients who are members of their particular health plan. So that's one important caveat. So at this point, you may be thinking, Mr. West, isn't it obvious when a provider-patient relationship is formed? The patient comes into my office, they fill out paperwork, and I see them, and voila, a relationship exists. Isn't that the case? Well, unfortunately, it's not always that simple. There are usually, however, 3 key indicators that I would suggest as being a good sign that there is a relationship. Number 1, have you billed for something? That's maybe the most solid criteria of all, but there can be a relationship in other situations. Has the provider undertaken some type of affirmative action on behalf of the patient? And even if they don't bill for that, that can still create a relationship. And secondly, even in situations where the provider never actually saw the patient face to face, was there a duty to take action? For example, an on-call doctor or in a hospital situation who had a duty to take action but never did. That could actually also establish a relationship in that situation. So let's talk about some exceptions, probably to the general rule, some scenarios where the issue of formation of a relationship is maybe not as clear as we may have thought. So I just mentioned one exception, and that is taking call. A doctor in a hospital, for example, may have a responsibility for patients in a particular unit, and even though he may never see a patient, he may have a duty to intervene if he gets information, nursing reports, or other things indicating that intervention is required for that patient. So we can actually have the formation of a relationship and actual liability to that doctor, even though he may never have actually seen the patient face to face. So a second exceptional situation, and that is that of the classic hallway consultation. So does that create a provider-patient relationship? And the answer is, in typical lawyer fashion, it depends. And it really depends on the facts of that situation. If the consultation is just a general discussion about how to treat a particular condition, say osteomyelitis, if there's just a general discussion, what do you usually do, what works best for you, that kind of thing, that is not going to create a provider-patient relationship. However, if the conversation goes beyond that to where the consulting doctor is actually suggesting and the other doctor is accepting a specific course of treatment, again, this can create an implied provider-patient relationship in that particular situation. All right, a third situation, and that is residents and supervisors. And here there really is a split of authority and disagreement among courts around the country as to whether the supervisor of the resident actually has a provider-patient relationship with the patient in that situation. There are many situations where residents may see a patient, the supervisor does not, but the supervisor may be monitoring, may be receiving reports, may be reviewing records, and the involvement of the supervisor may rise to a level where a court will say that there is actually a provider-patient relationship. And this may vary from state to state in different residency programs. So a fourth exception, and this is a little bit of an unusual case involving a referral to a specialist. There's a Georgia court, and I'm not aware of any other court so stating, but this court said that a primary care provider who referred a patient to a specialist could be responsible where the specialist committed malpractice. This being a situation where the court said that the primary care provider's mere act of doing a brief evaluation and referring the patient on to the specialist who then commits malpractice could be enough to create that relationship. I think that's a little bit of an unusual result, but nevertheless, just exploring the parameters of this subject, I noted that that case is out there. There are many situations in which providers are called upon to render what I call independent medical examinations. These are situations such as workers' compensation, disability evaluations, independent medical examinations in civil litigation, fitness for duty examinations for employers, even in domestic disputes, divorce cases, parental fitness examinations. And the common thread in all of these situations is that a third party is retaining the services of the provider rather than the patient. And in these situations, the majority rule is that no provider-patient relationship is created because, again, the entity retaining the provider is not the individual who is being evaluated. The one exception is if in the course of that examination there is a discovery of a serious health condition, particularly one that the individual is not aware of, the courts will say there is a duty to at least notify the individual that there has been this discovery and pass that on, and there can be liability for failing to do that. Other than that one situation, the courts will say that there is no provider-patient relationship in such situations. As a final example, and that is telemedicine, which as a result of the pandemic has really moved to the forefront as being a very important situation. And here, the establishment of a relationship is going to be a matter of state law, and different states have different requirements. Some states, such as Idaho, requiring that there be an initial face-to-face visit with either the provider or someone in the provider's clinic before a full provider-patient relationship can be established. Interestingly enough, in this scenario, it's usually the provider who is wanting to prove that a relationship exists because they're wanting to be reimbursed for that relationship, and they are also probably wanting to avoid any kind of licensure discipline for providing care in an inappropriate situation. So these are, again, situations involving the formation of a provider-patient relationship. As you can probably see, it is not always as clear-cut as we might expect it to be. With that, I'm going to shift now to another topic, a related topic having to do with whether a provider has permission or consent to provide treatment to the patient. I'm going to really talk more about general principles today. Next month, we're going to be talking about medical malpractice law in detail, and the issue of informed consent is going to be an important part of that discussion. So join us next month for a more extensive discussion of this particular issue. So I'm going to really talk maybe even about some philosophical underpinnings of the doctrine of consent. As I've taught at Boise State University on the issue of ethics and health law, it's very commonly understood that there are four basic principles, bioethical principles, if you will, being beneficence, non-maleficence, justice, and respect for individual autonomy. Those are considered the four keystone principles of healthcare ethics. The doctrine of consent is based on the ethical principle of respect for individual autonomy. And the United States Supreme Court 130 years ago said, as you can see on screen, no right is held more sacred than the right of every individual to the possession and control of his own person, free from all restraint or interference by others. And there are really three basic components of consent. First of all, a person has to have the mental capacity to make a decision, to give consent. Secondly, the person has to have sufficient information to make that decision. And the right to consent also includes the right to refuse care. So that's an important component to note as well. So let's talk about some of these for a moment. So capacity to decide. Ed's going to touch a little bit more on this in a moment, but this is usually going to be something determined by the provider based upon their face-to-face evaluation, really the snapshot they see in front of them at the moment. And usually most providers will ascertain whether they feel they're dealing with someone who has mental capacity. But when doubts exist, the provider is well advised to consult with others, with other providers, with family, in order to resolve any doubts that may exist. And when we're talking about capacity, we're talking about things such as a person's age and maturity, their mental ability, whether we have issues such as dementia or Alzheimer's, and whether we have any kind of impairment caused by a substance, drugs, or alcohol. Next, assuming that the patient appears to have sufficient capacity, then we look at the issue of whether the patient has been provided with sufficient information. And courts across the country, as well as in Idaho, have addressed this issue and really have decided that there are 4 or 5 basic components of information that should be given to the patient. The patient needs to be told, first of all, what their condition is. Secondly, they need to have explained the nature of the proposed care or treatment, which the treatment may not even involve any particular care. They need to have explained to them the benefits of that care, as well as the material risks of either the proposed care or going forward without that care. And secondly, they need to have explained to them the treatment alternatives. So if this is done in a discussion, that is typically going to be deemed to be sufficient information. One thing I need to emphasize, having worked with thousands of healthcare providers over the last 35 years, I often see the misconception that informed consent is a piece of paper, it's a form. And I always try to explain that, in fact, it's not a piece of paper, it's a process. The piece of paper simply confirms or documents that the process of getting consent hopefully took place. So that's an important thing. And it's important to note that under Idaho law and the law of many states, having a written piece of paper is not even legally required. But what is required is the process of informing the patient and getting their consent. In terms of the mechanics, as I've stated, consent may be given orally or in writing. It's very important to get it in writing because it creates documentation, and in some states' laws, it creates a presumption of informed consent. The contents of the consent form, as you can see, name of the procedure, risks, benefits, the fact that the patient had the opportunity to ask questions, and then signed and dated. Question often comes up, do I have to get consent for every single thing I do to a patient, or is it only required for quote unquote major procedures? And that's an area of significant controversy and disagreement. I know when I've gone in and had blood drawn, for example, I don't usually give consent for that as a very minor procedure. There are certain other very minor things that are done that typically I do not see consent for, but one has to use their judgment. If it's a procedure that actually involves any level of significant risk or complication, then I would advise in those situations that consent be obtained. There are a few special situations, and again, Ed is going to touch on some of these in a moment, but the special situations are with incompetent patients, and in that situation, we need to have a surrogate. Idaho law in section 39-4504 actually provides a hierarchy or list of surrogates that a provider may turn to in these particular situations, which is also true in the situation of an unconscious or incapacitated patient. So we have that same list of surrogates, and every healthcare provider should be familiar with this list of surrogates found in Idaho law. And then, of course, end of life situations, which now we're really involving typically a refusal of care rather than a consent to care. And in these situations, there's a lot of complexity. We have issues of physician-assisted suicide. We have issues of right to a natural death under Idaho law. And this is a complicated subject, and Ed is going to talk on that in just a moment. So with that, I am going to turn the time now to Andrew Alder and have him discuss the provider-patient relationship. I need to let you all know I have a hearing that is beginning with the judge in a few moments, and I will not be able to rejoin the conference later for the question and answer period at the end, but I'm very confident that Andrew and Ed will be able to address your questions. So with that, Andrew, I'll turn the time over to you.
All right. Thank you, Kevin. And good morning, everybody. It's good to be here with you, and we're happy that you're here with us, and hope that there's something useful you can take from this presentation. So Kevin discussed how the provider-patient relationship is formed and some of the nuances surrounding that. I'm going to talk about now how that provider-patient relationship ends and some of the nuances surrounding that, including and in particular a legal concept that we call patient abandonment and what providers can do in order to avoid patient abandonment claims. So when does the provider-patient relationship end? Essentially, there's three scenarios. So it's important to understand that once the provider-patient relationship has been formed, the provider has ongoing duties to provide care and treatment to that patient until that relationship has ended. And there's essentially three ways that that relationship can end. When treatment is no longer necessary, that relationship ends. If the patient terminates the relationship, obviously a patient can unilaterally at any time decide that they want to no longer receive treatment or go seek treatment elsewhere and can unilaterally end that relationship. And then finally, in the area that we're going to talk about today is when the provider terminates that relationship. Kevin touched on this, that a provider has the right and the prerogative to choose who he or she treats. And so a provider can unilaterally terminate a relationship, but it has to be done in a certain manner. So a provider, again, can terminate that relationship for essentially any non-discriminatory reason. And there are a lot of reasons for why a provider may want to end a relationship and terminate that provider-patient relationship. I have a few examples here on this slide: non-compliance, non-payment, drug-seeking behavior. There's many other examples. Ethical or legal conflicts may arise during the treatment process. The provider may have insufficient supplies or resources to provide adequate treatment to that patient. The patient may be canceling many appointments or not appearing for appointments, or there could be more serious things like inappropriate behavior, sexual advances, or the patient engaging in verbal abuse. So there are a lot of valid reasons for why a provider might want to end that relationship. But regardless of the reason, the provider needs to take certain steps in order to end that properly, and in order to avoid an abandonment claim. And one note too, you can see there on the slide that it can be terminated for any non-discriminatory reason. So obviously a provider cannot end a relationship based on a patient's gender, race, sexual orientation, etc., other federally protected rights. But other than discriminatory reasons, a provider can end that relationship. So let's talk a bit about what abandonment is. So patient abandonment is when a provider ends the provider-patient relationship while the patient actively needs care and without adequate notice that allows the patient reasonable time to obtain care elsewhere. So again, abandonment only arises in the situation where there's already a provider-patient relationship and that patient continues to need care. And so if that's the case, then the relationship can't end unless adequate notice is provided to the patient and they're given enough time to go find care elsewhere. There are potential legal consequences and penalties for patient abandonment claims, and they fall under essentially two categories. So first, the patient could bring a lawsuit against the provider for abandonment. This would be a form of medical malpractice. It would be a civil lawsuit. In order for a patient to succeed in such a lawsuit, they would need to prove that the abandonment resulted in some kind of injury or damage to that patient. The second category of potential consequences or penalties would be a Board of Medicine disciplinary action. So most states, including Idaho, under Idaho Code, there's a specific statute that provides for the various reasons that a Board of Medicine can take disciplinary action against a provider. One of those expressed reasons is patient abandonment. And so that would be an action against the provider's license that would be initiated by the Board of Medicine. So again, we talked about the various reasons for why a provider might want to end a relationship, even when ongoing treatment care is needed. But again, if any of those circumstances exist, it doesn't automatically end the relationship. So even if there's an outstanding bill, even if a patient changes insurance coverage and is no longer covered, or a patient is suing the provider, under any of those circumstances, the relationship doesn't just automatically end. There's still a process. So I want to talk just a bit about some real world examples of patient abandonment before I get to the dismissal letter. So I think most providers understand that you can't just abandon a patient, but I think it's helpful to go over some real world examples of how this might occur. So if a doctor intentionally refuses to treat a patient who is failing to pay medical bills, that would be patient abandonment, right? So a patient can't arrive for an appointment and the doctor say, you haven't paid your bills for 2 months, I'm not going to provide treatment. That would be patient abandonment. If a doctor is unavailable for an unreasonable amount of time when a patient needs medical care, as well as the backup or on-call doctor. So if that provider is not available when there's a provider-patient relationship that exists and that provider is unavailable, that can be an abandonment, patient abandonment. This can happen in the hospital setting. We're going to have another webinar later about hospital issues and hospital care, but it's important to understand that a hospital can be subject to an abandonment claim for having inadequate staffing. Some other examples regarding medical staff. So if medical staff fails to reach out to a patient who has missed an important follow-up appointment, that could be patient abandonment. If medical staff fails to communicate a question from a patient to the doctor, that could be patient abandonment. Or when a provider or medical staff schedules a procedure or an appointment that's too far in the future and results in preventable harm to that patient. So there's a lot of real world examples and things to be aware of in order to make sure your practice is set up in order to avoid those abandonment claims. So the dismissal letter. Again, if the provider wants to terminate the relationship, they need to do so by providing adequate notice to the patient. And this is typically done through what we call a dismissal letter. So a few do's and don'ts regarding the dismissal letter. First, and most importantly, the dismissal letter should clearly state that the patient is being dismissed from care. You don't need to provide a reason, although it's typically a good idea and advisable to provide a brief reason for why the relationship is ending. But understand that oftentimes less is more. It's advisable not to get into a lot of details or recite a whole bunch of facts that the patient may dispute. So make it short and sweet, but again, make it clear to the patient that they're being dismissed from care. It's important that the dismissal letter include the risks of not continuing treatment with another provider, because again, if the relationship is ending in a dismissal letter, it means that the patient still needs care, and so they should be advised as to the risks that they face if they don't go find treatment elsewhere. The dismissal letter should state the official date of termination. And again, they need to be provided adequate time to go find care elsewhere. The general rule of thumb is 30 days. That's generally going to be fine. But again, it may be case specific, depending on the needs of the patient and how available other providers in that particular community may be, and the ability of the patient to go find care elsewhere. Also important to understand that during that sort of buffer period after the dismissal letter goes out and before the 30 days runs, the provider still has an ongoing duty to that patient and needs to provide emergency care, needs to continue filling prescriptions, etc. The dismissal letter should also inform the patient of the right to access and obtain medical records, and also advisable to include the process and what the patient can do in order to obtain his or her medical records. And then it's important to retain a copy of that dismissal letter for the patient's medical record. Make sure that letter's copied and put in the medical chart before it gets sent to the patient, and also retain any other communications that may have occurred between the provider and the patient related to the termination of the relationship, so that everything's documented and remains in that patient's medical chart and record. A few don'ts with the dismissal letter. Be careful not to criticize the patient or appear hostile. Again, the letter, even if the patient has engaged in inappropriate behavior, the dismissal letter should be professional, should be short and simple, and not engage in attacking that patient or making them look bad. Additionally, it's advisable to think about the timing of ending the relationship. Each case is going to be different, and there may be situations where the relationship needs to end no matter what. But as a general matter, it's advisable not to terminate that relationship during a vulnerable time, such as immediately after an operation, when there may be post-op visits that need to occur in the near future. So think about when to end that relationship, and would caution against doing that when the patient is particularly vulnerable. I think that concludes ending the provider-patient relationship and abandonment claims. If there are any questions you have about that, please feel free to put that in the chat. And I think we're going to have a few minutes at the end for some questions and answers. So I will turn the time over to Ed now for the next topics.
Hey, Ed, this is Jason. Sorry to interrupt you. Your line is still muted.
Sorry about that. Good morning. Thank you, Jason. So I just want to begin. I'm coming at this a little different perspective. I'm primarily an estate planning attorney, and what we're going to talk about some of the documents that we generally prepare for clients as they put their kind of affairs in order. There's three basic documents that impact medical decisions. One's the HIP authorization form. We're not really going to discuss that today, but the two that really apply to patient care are a living will or advanced healthcare directive, and a power of attorney for healthcare decisions. So when we think about, before those even go into place, there has to be a determination of whether there's capacity. And so in this case, we talk about medical decision making capacity. And that just simply means the ability of the patient to understand the benefits and risk of a certain treatment. And obviously, whether an individual has capacity is the basis of informed consent. Now, generally, as Kevin alluded to earlier, it is the treating providers who is going to make that determination of capacity. If for some reason there's a determination of incapacity, it's also probably important to look to whether the patient has a living will or durable power of attorney that gives that right to determine capacity to someone else. That is not common in our Idaho forms, but as Idaho accepts advanced healthcare directives from all states, generally. So it's important to be aware of those, but however, if the provider is not aware of that, obviously they're in that position, they can go ahead and make that decision. So then we talk about capacity is assessed, when you're meeting with the patient. That's just a general part of life and responsibility and that part of that care. Generally, that's not very formal. However, in certain cases, it may be warranted if there's acute change in mental status. And I see, when I see this, is I see folks who are suffering from dementia or some related memory loss, disease, or activity. And one day they can be completely lucid, and the next day not. So in those cases, it's probably best to, more formally evaluate capacity. If individuals refusing a clearly beneficial treatment, or they're taking on a risky procedure without considering the risk. And in those cases, it may be best to get a more formal evaluation. In determining capacity, just like very similar to the will provisions, when a person can execute a valid will, as far as patient care, they need to understand the benefits and risks of the treatment, demonstrate appreciation of those benefits and risks, and show some reasoning in making that decision and be able to communicate their choice. And again, those are typically built into any dialogue that you as a provider is going to have with the patient. So here I'm going to skip through these, but these are just a couple slides that just show specific questions you can ask to determine or evaluate capacity. So then comes the question: what do you do if the patient lacks capacity? And this is where we get into our power of attorney for healthcare in our living will. So you need to ascertain whether they have one. Now, there is a registry in Idaho where many attorneys or clients will put their healthcare directive on this website. My experience is that happens less than it should. So you're often, as a provider, you're left with what documents they have provided, the patient's provided when they've come in. Now, if there's not a living will or a healthcare directive, the provider acts in their best professional judgment. So, and this kind of gives what I commented earlier, what if the patient has capacity but also has a living will or power of attorney? Well, the living will power of attorney don't come into effect until there is either an inability to communicate or lack of capacity. So anytime the patient has capacity and is able to communicate their desires, that takes precedence. So generally, what is a power of attorney? And so we're going to talk a little bit about what a power of attorney is and how it differs from a living will or advanced healthcare directive. Now, a power of attorney is a general form that grants authority to an individual designated in the document to decide the extent of the person's care. And it just gives someone, a trusted individual, the authority to make medical and life care decisions on their behalf. Generally, that person needs to be older than 18 years old. There are a couple exceptions under Idaho statutes of individuals who cannot be. A healthcare provider cannot be a power of attorney, neither can the owner of a community care facility. And generally, the respective employees are also excluded. Now, if the employees are a relation to the patient, they can be. However, that exclusion doesn't apply to the treating, the healthcare provider, or to the community care facilities. Now, Idaho, we have a form, and it's in section, I'm looking at 394510, which sets forth our general power of attorney, okay? And generally, that's the one you're going to see most often. And there's really very little deviation from that power of attorney form and the living will. And there's a couple of reasons for that. One is the reason I'm most concerned about is that, we don't want to we want to document that the physicians, the treating providers are going to be familiar with. It's not something that's new that they're going to have to spend a lot of time going through to understand. But that being said, Idaho law also allows you to deviate from that form, provided you comply with all the provisions of that section. So the power of attorney can be pretty tailored or just generally broad. My experience is most are broad, but the thing to consider is that, you know, we do have the Idaho form, but as I mentioned earlier, Idaho accepts forms from all states, and some states treat the power of attorneys quite differently. They're very, very specific. Now I want to just move on to the living will. So the living will differs. The power of attorney goes into effect at any time that an individual is incapacitated or lacks the ability to communicate. Okay. Now, living will goes into effect into life situations, and specifically, they can be. Sorry, let me. Got the form. So under Idaho law, it's if the individual has an incurable or irreversible injury, disease, that injury, disease is terminal, and their life will only be sustained through artificial measures, then the living will goes in place. Or alternatively, if they've are in a persistent vegetative state or a coma. So that's the specifics under Idaho law, under our statutory form, when it's in place. Again, living wills can be pretty specific or general. The question, some of the things they can address is whether they want to be on ventilation, attached to feeding tubes, what type of pain medication they want to receive, giving IV fluids to sustain life. Now, under the Idaho form, it's pretty specific. There's basically effectively three options. The first option is, you know, basically do everything to keep me alive, and this could say any and all artificial life-sustaining measures are to be used. The second option is withdraw all artificial life-sustaining measures except an option to receive food or water through an IV or both. And the final option in the Idaho form is simply withdraw all artificial life-sustaining measures. There's nothing in our standard form that deals with pain medication. That's understood that they would get, you know, some sort of medication to ease pain. Now, it's important to realize these directives, whether the living will or an advanced healthcare directive, are different from a DNR, which is focused on certain types of the medical procedure. And so and as I've already mentioned, you know, these become effective when executed. However, they don't go into, what's the right word, into play until the patient lacks capacity or is unable to communicate. So specifically with the power of attorney, as when I advise clients, I let them know it's effective immediately, but if you can communicate, then you override that. But someone could simply fall down and hit their head, be unable to communicate, and the power of attorney would go into effect. Now, we've already talked about specific times when the living will goes into effect. Now, occasionally, some power of attorneys, and this is rare under Idaho, at least in Idaho, but I have seen it in other states where the document is not effective immediately, and they reference a future event, or they define incapacity within the document itself as to when it becomes effective. But that's not the default rule. The default rule is it's effective on execution. Now, these documents can be revoked at any time by the patient, by the client. They can destroy the document. They can sign another writing expressing that intent. However, the one issue is often there's a notice requirement that if an individual is going to terminate a living will or power of attorney, they must give notice. And so that's important to know. But however, if the healthcare provider doesn't have actual knowledge of a revocation, they're not liable for that. Just a couple of practical tips. You know, what happens when you have a living will or power of attorney that conflict? Now, that's That's very unusual under Idaho just because they cover different situations. However, I have seen that with out of state where different types of provisions in the power of attorney that we generally don't put in there. But the patient, if they do conflict, the living will controls or the advanced healthcare controls the power. The agent for healthcare decisions cannot override a living will. Now, generally in our standard power of attorney form, it talks about to the extent the agent in fact has knowledge of the individual's wishes, they could use that knowledge to supplement what's in the living will and things that aren't covered, or obviously use it if they're just acting pursuant to the power of attorney. As I've already mentioned, Idaho's policy is to accept power of attorneys or living wills from all other states, with a couple exceptions. The prior wishes or directives cannot authorize or force euthanasia or futile care. So with those two exceptions in mind, we accept the documents from other states. So what if the terms of the living will go against the standard of care? As it's, under Idaho Code, healthcare providers and personnel are immune from civil or criminal liability as well as discipline for unprofessional contact or actual omissions carried out or performed in good faith, pursuant to living wills or other healthcare directives. So, under Idaho law, at least if you're acting pursuant to a living will, if you're following what has been expressed in the living will, or more likely the power of attorney, you can act, and there's this shield protection that as long as the provider's acting in good faith, there's no liability. So with that, I think I'll turn the time back over to Jason for questions.
Great, Ed. Great, Ed. Thank you very much for your presentation there. And Andrew, a big thanks to you as well. So we have a few remaining moments. I'd like to invite both of our panelists back on. Thanks, Ed and Andrew. And for those of you that are with us, please feel free to submit any questions that you may have. We'd be happy to address those in the next 7 or 8 minutes that we have left. We do have a couple of questions that have come in. And Andrew, I think I'll start with you. This question came in during Kevin's presentation. And the question is, do I need to meet with the client or patient before doing telehealth? And Andrew, your line's mute. There we go.
I'm back on. So if I understand the question, if the question is whether a provider-patient relationship is created only if there's an in-person meeting, the answer is no. I mean, a provider-patient relationship could be created just through a telephone appointment, and you don't necessarily need to meet with the patient in person before that relationship is going to be formed. So if I understand the question correctly, if not, please clarify your question. But I think that's the question, and no, a provider-patient relationship could be formed just based on a telephone consultation.
Great, thank you, Andrew. It looks like we have another question that may have been answered, but I'm gonna address this again. So this question is with respect to our location here in Utah, and one of our attendees is a counselor licensed in Utah. Can you speak to any differences between Idaho and Utah relating to any of the topics presented today, or is that too nuanced?
So I can let Ed chime in here too, but for my part, there are general principles regarding the formation of the provider-patient relationship and the termination of the provider-patient relationship that generally apply across all states. There are nuances. Some states will have specific provisions either through the Board of Medicine or by statute that clarify how exactly a relationship needs to be terminated. But in Idaho, for example, there's no specific statute or guidance on that. And so these are just general principles that apply really nationwide. But there are nuances. I'm not a particular expert on Utah law. If there's any specific area, we have healthcare attorneys both in Idaho and Utah, and we can certainly, provide that information if there's a specific question. But we were speaking today more generally, principles that apply really in all states, but there are nuances to particular issues.
Great, thanks, Andrew. Ed, do you want to expand on that?
Sure. It's regarding power of attorneys. Those are generally in the Uniform Probate Code, so those are pretty consistent. Utah's adopted that as well as Idaho, and I believe Nevada. As far as the Advanced Healthcare Directive, the statutory form in Utah it's similar, but in the same time quite different. It actually has a lot more options for the patient to choose from. You said the Idaho one is pretty generic and just 3 basic things. The Utah one, again, is a statutory form, but it breaks it out quite a bit more. So.
Great, thanks, Ed. Here's a question concerning ending a patient relationship. And could you speak to how to handle ending a patient relationship that comes about as a result of no longer accepting a particular insurance?
Yeah, so of course, a provider can end a relationship based on that. If the patient changes insurance or the provider no longer accepts a certain insurance policy, the relationship can end. But again, it doesn't just end automatically. You still have to provide adequate notice to that patient that gives them sufficient time to go find another provider that takes their insurance, or another provider that they want to go and get care from. So yeah, if the patient still has active medical issues and still needs care and treatment, you need to provide that written notice through a dismissal letter and give them, again, the general rule of thumb is 30 days to go find another provider. And then during those 30 days, you need to continue to provide care, especially if it's an emergency or an urgent issue, and you need to continue to fill prescriptions, et cetera, until you've given them that adequate time to go find someone else.
Great, thank you, Andrew. Ed, any other thoughts from you on this question?
No.
Okay. One other question that's come in, and Andrew, I think this is directed at you. So if a client that has a risk issue and discontinues therapy with a provider, is it the provider's responsibility to send a termination letter after encouraging them to continue therapy during a vulnerable time?
No. A patient can terminate the relationship, and that doesn't obligate a provider to do anything specific. I do think that it's probably advisable to document the fact that you've told that patient. You could do it through some sort of a dismissal letter, but the dismissal letter is really more intended for when the provider is the one who's ending the relationship. If the patient's ending the relationship, that doesn't put an obligation on the provider to do anything specific. But it should be well documented that the provider has sort of warned the patient that they need care. They should continue to get care, whether it's through that provider or another provider. Make sure that's documented in the medical chart.
Great, thank you very much, Andrew. Ed, any final thoughts on that?
No, thank you.
Okay, well, in closing today, I'd like to extend a huge thanks to all of our presenters for putting this presentation together. Andrew Alder out of our Boise office, Ed Cather out of our Idaho Falls office, and Kevin West out of our Boise Boise office. Thanks to you, gentlemen, for your insights, your guidance, and your time today. I'd also like to thank each of you for joining us for today's webinar on patient care. As Kevin West indicated from the very outset of the presentation, this is an ongoing series. Our next presentation is scheduled for, Wednesday, October 13th from 8:30 to 9:30 a.m. You will be receiving information on how to register for that event. Also, we will be providing you with a link to today's recording, a copy of today's PowerPoint presentation, and again, more information on our upcoming webinar series. So thanks again to all of you for joining us and for your time today, and we hope to see you on Wednesday, October 13th. Thanks again.
Thanks, Jason, and thanks to everyone who joined us.
Thank you.